In this video, we're going to talk about public disclosures of your invention and how those public disclosures could harm your ability to get a patent on your invention. As we talked about in a prior video, being new or being novel is an important threshold for your invention to cross in order to receive a United States patent. Very generally speaking, the newness of your invention is judged as of the filing date of your patent application. That means as of the filing date of your patent application, the Patent and Trademark Office will look at all public information in existence in order to determine whether your invention is actually new and therefore patentable. It's important for inventors and entrepreneurs to understand that their own public disclosures, that means the public information that they themselves create, such as scientific publications, presentations, YouTube videos, or conversation with others in the field, those will count as public disclosures or prior art that could negatively impact the newness of their invention when they later try to file a patent application and receive a United States patent. So there's a couple of important things to know. One is that in the United States, there's something called the grace period. That means that from the date of your own public disclosure, you have 1 year to file a United States patent application, and that earlier public disclosure will not count against you when the Patent and Trademark Office tries to determine whether your invention is new. Now there's some new nuances to this concept. First is that on March 16, 2013, the patent laws in this country changed, and that grace period is no longer as strong as it used to be. It used to be the case that you had 1 year from your own public disclosure or the public disclosure of anyone else in order to file a United States patent. And as long as you were the first to actually invent that technology, you could still receive a patent. As of March 16, 2013, the law changed, and that 1 year grace period only extends to your own public disclosures or the disclosures of a third party that derive their information from you. This means that if you publicly disclose your information, you may have 1 year to file a patent application, and that public disclosure of yourself won't count against you. But if someone else on their own comes up with this invention and publicly discloses your invention, that public disclosure will immediately bar you from getting a United States patent. The other important thing to notice is that in Europe, there has never been a 1 year grace period. That means for purposes of getting a European patent or a patent in several other important jurisdictions in the world, a public disclosure even 1 day before your first filed patent application will bar you from getting a patent. In this way, it's very important to track your past or upcoming public disclosures of your invention because they could have drastic implications on your ability to get a patent on that technology.